The International Court of Justice is now in session. President Crawford and the Honorable Judges Simma and Robinson presiding.
Please be seated.
The case before the court is the case concerning the Sisters of the Sun. The parties are Applicant, the Federation of the Clans of the Eton, versus the Respondent, the Kingdom of Rahad. The Applicant and the Respondent are each allocated 45 minutes to present their pleadings.
So we start with the speakers for the applicant, and the first speaker is Mr. Phillips.
May it please the Court, my name is Joel Phillips and I appear as agent for the Federation of the Clans of the Etan, together with my co-agent, Alyssa Glass. I will speak for 21 minutes concerning Rahad's use of the aquifer and Rahad's obligations with respect to the Kin Canyon complex. Ms. Glass will speak for a further 22 minutes concerning the Ruby Sippa and Rahad's claim for compensation in respect of the Kin migrants. We reserve 2 minutes for rebuttal. Mr. President, Your Excellencies, the Greater Inarta Aquifer straddles the border between Etania and Rahad. The people of the Nomad Coast have relied on its natural discharge for generations. Despite that common history, in 2006, Rahad began extracting the aquifer's waters at such a rate that it will entirely drain the aquifer within 20 years of these proceedings. That use has already rendered more than 20% of Etania's farmland unfarmable. I have two submissions. First, that Rahad's extraction of water from the aquifer violates its obligation to use that resource equitably. And second, that Rahad's Savali pipeline operations violate its international obligations with respect to the Kin Canyon complex, and therefore must cease. Turning to my first submission, within this submission we make 2 points. First, that customary international law requires states to use transboundary aquifers equitably. And second, that Rahad has breached that obligation. Turning to the first of those points, the existence of a customary obligation, we submit that the principle that transboundary aquifers must be used equitably has been incorporated into customary international law through settled state practice, accompanied by a belief of legal obligation, thus satisfying the test set out by this court in its 1969 decision in the North Sea continental shelf cases at paragraph 77.
Simma has a question.
I have a question. I'm new to the court, and I always thought that equity was kind of in the corner in Article 38, paragraph 2, and now you mix up, don't you mix up custom and equity by speaking of customary rules prescribing equitable treatment, or how would you treat?
Thank you, Your Excellency. We don't talk of equity in the abstract here, but rather the custom that we seek to assert has a particular specified content, which we say is set out in the International Law Commission's 2008 draft articles on the law of transboundary aquifers, and in particular Articles 4 and 5, which set out a number of factors which inform an evaluative judgment to determine what is an equitable and reasonable accrual of benefits. Now,
what indication is there that the Commission adopted those articles as customary international law?
The Commission's mandate, as is noted in the articles, was to codify the law in this area. And it's our submission that the content of the articles has been incorporated into customary international law through settled state practice in the form of its inclusion of similar obligations in a number of multilateral conventions, together with the UN General Assembly's response to the draft articles in the form of a series of UN General Assembly resolutions. We rely on the latter for evidence of opinio juris.
But the Commission also has the task to develop international law progressively, right? And I think they say somewhere, I've read, that you cannot really discern in a text produced by the ILC what is codification and what is progressive development. And don't you have the idea, don't you have think that these principles are more progressive development?
Not in this case, Your Excellency, because the draft articles on which we rely note, and this is in the commentary to Article 1, paragraph 2, that the International Law Commission's mandate here was to codify the law. We accept that, in general, its mandate also includes progressively developing it, but it's our submission is that it was codifying law here, and that, moreover, there is extensive evidence of settled state practice with respect to specially affected states, which in the 1969 North Sea cases this court held should be given special weight in determining whether there is sufficient state practice.
Could you give us some examples of what you call the settled state practice in this area?
Certainly, Your Excellency. The UNESCO International Hydrological Programme has identified 24 states that either rely on extraction from aquifers or which benefit from natural discharge from aquifers. It's our submission that those are specially affected states, and of those 24, 17 have entered into equitable use agreements. Now, the treaties into which they've entered include, for example, the 1992 UN Economic Commission for Europe Convention on the use and protection of transboundary watercourses and international lakes. That has 41 states parties, so demonstrates acceptance even among the wider international community and requires equitable use in Article 2C.
That's a regional convention, but we're talking about general international law.
We are, Mr. President, and in that regard, we also look to the 1997 UN Watercourses Convention, which was adopted by the UN General Assembly with a vote of 103 in favour and only 3 against, and requires equitable use in Article 5, including with respect to transboundary aquifers that are connected to surface waters.
Has it ever entered into force?
It did in 2014, Your Excellency.
For how many parties?
Your Excellency, approximately 36 parties. Turning to opinion Europe.
That only applies to aquifers which are connected to international watercourses.
Yes, Mr. President.
What practice is there in relation to isolated aquifers such as this one?
The UN Economic Commission Convention, to which I referred, also applies to aquifers that are not connected to surface waters. There are also agreements, such as the Illumedan Aquifer Agreement. The parties to that include Algeria, Mali, and Mauritania. That is not limited in terms to aquifers that are connected to surface waters. Similarly, the Nubian Sandstone Aquifer Agreement between Egypt, Libya, and Sudan. Now, as to opinio juris, we rely on this series of UN General Assembly resolutions. Each resolution, and then there are 4, the first is from 2008, the others are from 2011, 2013, and 2016. Each of them is entitled the Law of Transboundary Aquifers, and each of them was passed by consensus with no votes against. Each of them commended the International Law Commission's articles to the attention of governments for guidance as to their obligations with respect to transboundary aquifers. For those reasons, namely the existence of settled state practice accompanied by a belief of legal obligation, we submit that customary international law requires states to use transboundary aquifers equitably. And turning to...
Who decides what equitably means? The 2 parties in a case? Could that be the reason that the declaration just passed unanimously, that they don't really commit you too much?
Not on our submission, Your Excellency. We submit that there is a clear content of the equitable use obligation, which is set out in particular in Article 5 of the International Law Commission's Aquifer Articles. Now, those articles make clear that equitable use is determined by an evaluative judgment, having regard to factors such as the effects of use on the aquifer states, those states' relative dependency on the aquifer, the availability of alternatives to depleting the aquifer, and the aquifer's natural characteristics. It's our submission that what makes Rahard's use inequitable here is that when those factors are taken together, Rahard's use has disproportionately benefited Rahard to Atania's detriment.
You say disproportionately benefited, but we understand that this aquifer can't be recharged by recharge processes in ordinary historical time. So what was the respondent to do, faced with a water shortage, but to access the available water? How could they have complied with international law in the present circumstances?
Well, Mr. President, we submit that they should have, for example, continued to import some level of water. Both states have previously imported water during a drought. We know that from paragraph 14 of the compromise. And Atania continues to import water. By contrast, Rahad has not imported any water since 2007. That's from clarification 9. It's our submission that the inequity there is that Rahad has left Atania as the sole state that is seeking to conserve or prolong the life of this shared resource. We also point to inequity in the form of the disproportionate impact of Rahad's actions on Atania's farmland. Rahad has already drained over 1/3 of the aquifer's waters, using the figures in paragraphs 21 and 26 of the compromise, and that has permanently lowered the water table in the region, thereby depriving Atania's farmland of the ability to benefit from the aquifer's natural discharge. That's from paragraph 28 of the compromise. So whilst Rahad has benefited immensely from access to the aquifer, Atania is faced with mounting and rising costs.
Why don't you access the aquifer? It's on your side of the boundary as well. Isn't that a simple answer?
Well, Mr. President, one reason is that Rahad's use of the aquifer has already caused damage to the Kin Canyon complex, which is a priceless World Heritage Site. That's the subject of the second submission that I'll make. But our submission on this point is that if Atania itself had tapped the aquifer, that would have exacerbated the risk of future damage to the complex.
Is there any analogy between aquifers and, for example, hydrocarbon reservoirs that cross state borders?
To an extent, Mr. President, the difference is that hydrocarbons aren't essential to human life in the same way that water is. But even in the case of hydrocarbons, it wouldn't be open to a state such as Rahad to unilaterally extract as much. Rather, it would be required to enter into a unitization agreement.
Now, you say required by general international law to enter into a unitization agreement. What's your authority for that proposition?
Your Excellency, that has been demonstrated by state practice, for example, by the United States. But on this particular point, the strongest argument against us, in fact, relates to the aquifer's natural characteristics and the fact in the compromise that 65% of the aquifer's surface area is in Rahad. That's in paragraph 15 of the compromise. However, that is all the compromise tells us. It doesn't tell us anything about the distribution of the aquifer's waters. And therefore, it's our submission that very limited weight should be placed on this because, in fact, there is often a great disparity between the distribution of an aquifer's surface area and the distribution of its volume or the waters. For example, taking the Ogallala aquifer in the United States, 37% of that aquifer's surface area is in Nebraska, and yet 66% of its volume is. So our submission is that whilst the natural characteristics are relevant, in the
do they apply public international law between Nebraska and Omaha or whatever? Or how legitimate is it to draw the analogies here?
No, Your Excellency. Our only point is that in order to conclude that 65% of the aquifer's water is in Rahad requires an inference from the distribution of the aquifer's surface area, and that is not the only reasonable inference, and thus, in accordance with this Court's first decision in the Corfu Channel case, it cannot be drawn. The reason it isn't the only reasonable inference is because there could be a disparity between surface area and volume, as there is with the Nebraska.
But let's assume there is no such disparity. What would the consequence be?
Well, in that case, Your Excellency, we would accept that it might be equitable for Rahad to receive 65% of the aquifer's benefits. But what we are actually faced with is a situation where Rahad is receiving nearly all the aquifer's benefits, and Atania is facing rising and mounting costs due to the loss of its farmland and due to the cost of importing water.
Is that a statement by Atania which is binding under international law? If you as counsel or agent in front of the court says we will be happy with 35% of the aquifer and leave the 65, can we rely on that this is binding?
No, Your Excellency, and instead we would point to Article 5 of the special agreement. Under that article, the states have undertaken to execute the court's judgment in good faith and to enter into negotiations as to modalities for its execution. Now, our submission is that it is for the court to set out the principles governing that negotiation, and we say they are the principles set out in Article 5 of the Aquifer Articles, and it is then for the parties to negotiate that outcome. The declaration...
That's precisely what I mean. If you say before the court, your government, you will be happy, you will be satisfied with obtaining 65% of the water, isn't that will lead to very brief negotiations, right?
Not quite, Your Excellency, because the source of inequity here includes the damage to Etania's farmland. Now, that is something to be taken into account in the distribution of those benefits.
But if counsel for the respondent, in effect, before this court, said it would be equitable for you to have 35%, wouldn't that be something we could take into account in determining the equities?
We accept it as a relevant factor, the distribution of water, but our point is that there are other factors that must also influence the equitable balance, and those include the impact of utilization on Etania in the shape of already more than 20% of Etania's farmland being rendered unfarmable by Rahad's actions. Your Excellencies, for those reasons, we ask this court to declare that Rahad's use is inequitable. Turning to my second submission, here, our submission is that Rahad is in ongoing breach of its obligations in relation to the Kin Canyon complex under the 1972 World Heritage Convention. Now, 3 points are not in dispute. First, both states are parties to that convention, which we know from clarification 10. Second, the complex is protected heritage for purposes of the convention. That is evident from its World Heritage listing at paragraph 13. And third, the respondent accepts at page 11 of its memorial that Rahad has obligations with respect to the complex under Article 6, paragraph 3 of the convention. There are, however, 2 points of disagreement. The first is what the convention requires Rahad to do. The second is whether it has breached its obligations. As to the content of Rahad's obligations, Article 6, paragraph 3 provides that parties must refrain from deliberate measures that might damage, directly or indirectly, heritage situated on other states' territory. Now, under Article 31, paragraph 1 of the 1969 Vienna Convention on the Law of Treaties, to which both states are parties, the provision must be interpreted in accordance with the ordinary meaning of its terms, in their context and in light of the World Heritage Convention's object and purpose. We submit that applying that rule, Article 6.3 prohibits not just deliberate measures intended to damage heritage, but also deliberate measures that might cause unintentional damage to heritage. That accords with the ordinary meaning of the article's terms, which is that deliberate precedes measures rather than damage. That is, deliberate modifies measures. And second, it is confirmed by subsequent practice in the application of the World Heritage Convention, which this court must take into account.
I have a problem with logics. Maybe I'm a little late, but if you say the convention also prohibits unintended injury, how can you know, then how can you ever start a project which might endanger? If you only find out that you're in breach, can you prevent a breach by, the only way of preventing a breach would be what?
By ensuring that the state does not take deliberate measures that might cause damage. That is, it is a precautionary standard, and the obligation goes to the state's conduct.
But at what point of time does it go to the state's conduct? Are you saying international law prohibits a state from engaging in the development of its own natural resources in its own territory if there is a mere prospect that damage may be caused to another state?
Not quite, Mr. President. Rather,
I'm relieved to hear it.
We're relying here on the treaty provision, and in particular on its reference to measures which might damage heritage. Now, as to the breach of that obligation, Rahad's operation of the pipeline has already caused damage to the complex. We know that from paragraph 30 of the compromise. And Rahad is undertaking a deliberate measure by continuing to operate the pipeline and continuing to extract the aquifer at a rate of 1.2 cubic kilometers per year. So it is continuing to undertake an action that has already been shown to cause damage. Moreover, as a result of the damage that was identified, the complex has been placed on the list of World Heritage in danger. This is from paragraph 32 of the compromise. The significance of that listing is that it identifies the complex as being threatened by serious and specific dangers which is the standard for danger listing under Article 11, paragraph 4 of the World Heritage Convention.
The World Heritage Committee made recommendations to the respondent state in relation to potential harm to the heritage items. Does the fact that those were recommendations affect matters?
Yes, Mr. President. On our submission, that is a further factor that indicates that Rahad's pipeline threatens damage to the complex. That is because the measures, and these are in clarification 6, are measures regarding the pipeline. Now, that implies, we submit, that the uncorrected pipeline in its current form threatens damage to the complex. For those 3 reasons, namely the fact that...
That wasn't really my point. My point was if this takes the status of a recommendation, it's not an adverse finding as such. It's a de bene esse type of recommendation, which is in terms not binding.
As to the committee's position, Mr. President, it operates by consensus. Here we rely primarily on its decision to list the complex as heritage in danger. Our submission is that the corrective measures indicate that the uncorrected pipeline poses a risk of further damage. And for those 3 reasons, namely, this is an operation which has already been shown to cause damage. It has led to the complex being placed on the list of World Heritage in danger, identifying it as threatened by serious and specific dangers. And Rahad itself accepts that corrective measures are necessary. For those 3 reasons, we submit that Rahad is in ongoing breach of Article 6, paragraph 3 of the World Heritage Convention. And the corollary of that ongoing internationally wrongful act is an obligation to cease Rahad's wrongful conduct in accordance with this court's 2004 advisory opinion in respect of the construction of a wall at paragraph 150. I defer to my co-agent to continue the case for Etania.
Thank you, Mr. Phillips. Ms. Glass.
Mr. President, Your Excellencies, on behalf of the applicant, I have 2 submissions. First, that Rahad must immediately return the ruby Simma to Etania, its lawful owner, and secondly, that Etania owes no compensation to Rahad for any costs incurred related to the kin migrants. Turning first to the ruby Simma, here our submission has 2 limbs. First, that a customary obligation has crystallised from Article 7b of the 1970 UNESCO Convention, requiring states to return cultural property stolen from museums and other similar institutions to its state of origin. Secondly, that by receiving Etanian stolen cultural property in full knowledge of its theft, refusing to return it, and accepting the Simma as Rahadi lawful property, as described at paragraphs 50 and 52 of the compromise, Rahad breached that obligation.
Ms. Glass, what are you going to do with the ruby Simma when you get it back?
Mr. President, on our submission, we cannot say what Etania will do in respect of the Simma as to the question of whether it will display it, for example. However, in accordance with the presumption of good faith, as described in the Lac-La-Nou arbitration at page 142, and in accordance with the presumption of legality stated by this court in its rights of passage decision of 1957, this court should not presume that were Etania to have the Simma returned to it, that it would take any measures of destruction against the Simma.
Ms. Glass, I asked you a question about your intentions and you reply with a presumption.
Yes, Mr. President, I did. However, I cannot speak to what Etania's actions will be in the future. All we can do is look to the facts in the compromise, and those facts are that even at the height of the Etanigrad protests, the Etanian government took no measures of destruction against the original ruby Simma, but placed it in a vault when Etanigrad was in a situation of chaos, disorder, and where conditions had become unsanitary and dangerous, as described at paragraph 42 of the compromise. Those are the facts before this court, and this court should not infer that were Etania to have the Simma returned to it, it would take any measures of destruction. The Simma remained in storage until, during the height of the protests, it was stolen from Etania, and the Simma had been on display since 1996 in the Kin Canyon Complex Cultural Centre. There is therefore no basis to suggest that Etania would not display the Simma were it to be returned from Etania to Etania. As to the existence of a customary obligation, we agree with the respondents at page 20 of their memorial that Article 7b in its treaty form cannot apply to the Simma because the UNESCO Convention had not entered into force for Rahad when Rahad received the Simma on the 3rd of October 2014. However, by that date, Article 7b had, on our submission, crystallised into customary international law because it had satisfied the conditions set out by this court in the 1969 North Sea cases for a treaty provision to crystallise into a customary obligation. First, the provision has a fundamentally norm-creating character because it imposes clear, specific obligations capable of binding states generally. In this respect, it can be contrasted with the provision that lacked such a character in the North Sea cases, that was Article 6 of the Geneva Convention on the Continental Shelf, which only applied in the absence of agreement between states and thus had a qualified nature.
Could you point out articles in the UNESCO Convention which would not be fundamentally norm-creating?
Perhaps Article 10, Your Excellency, which refers to states taking measures to promote education. That is a more aspirational obligation in its terms and less clear and specific.
Be careful, because I've been a member of the Committee on Economic, Social and Cultural Rights for 10 years, and I heard just too often this argument that these obligations are aspirational only.
I'm not sure that Judge Simma's extrajudicial accomplishments are relevant in this case.
Your Excellency, Mr. President, I do not submit positively, of course, that Article 10 lacks that character. However, here, because we rely on Article 7b, it is our submission that that provision has the fundamentally norm-creating character.
Because you rely on it.
Yes, Your Excellency, indeed. And because not only because we rely on it, Your Excellency, but because in respect of Article 7, unlike other articles of the Convention, perhaps, there is the necessary settled state practice backed by a belief of legal obligation. In particular, in respect of a core obligation of return stated in Article 7b, for state practice and opinio juris, we look to the fact that 139 states, including 25 non-parties to the 1970 UNESCO Convention, have passed 29 General Assembly resolutions since 1973 on the return or restitution of cultural property to its countries of origin. In accordance with this Court's 1986 Nicaragua decision at paragraph 188, such resolutions can show the evolution of opinio juris required for the formation of a new customary international law rule. If we look to the language, yes, Mr. President.
Keep going. I'm
Okay. All right.
simply contemplating questions, not asking them yet.
That's quite all right, Mr.
When I ask a question, you will know it.
Okay. If we look to the language of the resolutions in respect of opinio juris, we see that they demonstrate that states believe that they were under a legal obligation. The resolutions use language such as the fact that prompt restitution would make good the serious damage suffered by countries as a result of their removal of cultural property, and that restitution constitutes just reparation for damage done.
Is this obligation of restitution, does it attach to ownership or does it attach to something belonging to the cultural heritage of a country?
To the latter, Mr. President. The requirement is only that the item is the cultural property of the state in question, and to that end we look to Article 1 of the 1970 UNESCO Convention defining cultural property, which on our submission necessarily crystallised into customary international law along with Article 7b.
So the fact that the ruby Simma was stolen is irrelevant?
Not irrelevant, Mr. President, because the Article 7b obligation applies to cultural property that has been stolen from museums or similar institutions. So it is relevant to that second aspect of the article. However, the property may be owned, for example, by a museum or a university and yet be the cultural property of a state. in accordance with the Article 1 definition. Here, the SIPA is Atanian cultural property because we know from paragraph 12 of the compromise that it is the product of an archaeological excavation on Atanian national territory and has been designated by the Atanian state as of importance to Atania at paragraph 60 of the compromise.
You don't argue that it's part of the Rahad's cultural heritage as well?
Not under the definition of the 1970 UNESCO Convention, Mr. President. We recognise that the SIPA has significance for all peoples of the Nomad Coast. However, it is particularly significant to Atania. It symbolises the unification of all 17 Atan clans and their fight against Ifan, the desert fox, at paragraph 8 of the compromise. However, it was 16 of those 17 Atan clans which united again and formed the Federated Nation of Atania, as described at paragraph 10 of the compromise. SIPA is...
You have pointed to the UN General Assembly resolutions calling for return, but in actual practice, what do the statistics show?
They show, Your Excellency, that the United States, for example, has in the last decade returned 7,800 items of cultural property to over 30 different countries, including to countries which are not parties to the 1970 UNESCO Convention, and therefore where the US was under no strict treaty obligation of return. In 2014, the US returned 30 Vinyano statues to Kenya, despite the fact that Kenya is not a party to the UNESCO Convention. Similarly,
the United Kingdom has not returned the Elgin marbles.
It has not, Mr. President. However, the customary obligation that we assert applies to cultural property stolen after 1970 because state practice is to draw a sharp distinction between property like the Elgin marbles taken in the colonial era and property taken after 1970. In 2014, UNESCO conducted a survey of all of its member states, and 70% of respondents stated that all or most of their museums had adopted policies in line with the 1970 UNESCO Convention, that is, using 1970 as the baseline date for acquisitions of cultural property. The British Museum, although it has not, Mr. President, returned the Elgin marbles, has, as of 2006, adopted a policy prohibiting acquisition of cultural objects which lack legal provenance predating 1970. Similarly, Germany in 2013 returned a winged seahorse brooch to Turkey, even though that brooch was exported from Turkey in 2005, and therefore, when Germany ratified the UNESCO Convention only in 2007, the Convention could not apply in its strict terms to the brooch.
What do you say then about the United Kingdom? Is it or is it not in breach of customary international law by its failure to return the Elgin marbles?
It is not in breach of the customary obligation we assert, Your Excellency, because that obligation only applies to cultural property stolen after 1970, and the Elgin marbles were purchased by the British Museum in 1819. So we do not make any submissions in respect of that particular acquisition. We know that these returns were done out of a belief of legal obligation and not merely out of comity or a sense of friendship, not only because they were done outside the scope of the strict treaty obligation, but because they were accompanied by statements from states indicating that they consider themselves under such an obligation. The return from Germany to Turkey, which I mentioned, was accompanied by a statement from Germany's Minister of State that it underscores Germany's resolute action to fight the illegal cross-border trade in cultural property, and with a statement from Turkey stating that items taken in illegal and unauthorised ways must be returned. We further point to the fact that 131 states, including 46 non-parties to the 1970 UNESCO Convention, have enacted municipal laws specifically on restitution of cultural property, and in accordance with this Court's 2012 jurisdictional immunities decision, at paragraph 55, that is state practice of particular significance. Therefore, we submit that by refusing to return the Ruby Sipa to Atania, Rahad has breached this customary obligation, and that the consequence of that internationally wrongful act is for Rahad to make restitution of the Sipa in accordance with Article 35 of the 2001 Articles on State Responsibility, which we submit codify the law in this particular area. Turning then to the final declaration on the kin influx into Rahad. The Rahadi state is claiming compensation for the costs it has incurred as a result of accepting kin migrants from Etania. The respondent, at page 25 of their written memorial, relies on the principle that one state must not use its own territory in a way that injures another state's territory. The respondent argues that where one state causes a refugee outflow that harms the receiving state's territorial integrity, it breaches customary international law prohibiting transboundary harm.
How does say the march of refugees over a boundary violate the territorial integrity of a state?
It is our submission that it does not violate the transboundary harm principle, Your Excellency, and that indeed that principle is inapplicable to cross-border flows of people. We submit, however, that even if this court were to find that principle applicable, it cannot be applied in this case because Etania has not caused the kin to leave its territory as refugees. On the first point, the reason we submit that the transboundary harm principle is inapplicable to cross-border flows of people is because they do not involve a relevant harm. The International Law Commission's 2001 draft articles on the prevention of transboundary harm from inherently harmful or hazardous activities define harm as limited to physical consequences in Article 1.
Excuse me, a question, just a clarification. A few minutes ago you said the 2001 article is on state responsibility, and now you say the 2001 draft article is on prevention. What makes you call the ones draft articles and not the other? What was the difference?
Simply that draft articles is in the title of the latter 2001 articles, but not in the specific title of the 2001 articles on the responsibility of states for internationally wrongful acts.
Sorry, I didn't understand that. Was there a difference in the treatment of the one and the other?
There is not a difference in their legal status, Your Excellency, in that both form subsidiary means of determining the law under Article 38(1)(d) of this court's statute. Simply the specific title of the 2001 Articles on the Responsibility of States for Internationally Wrongful Acts does not, as it happens, include the word draft, whereas the 2001 Articles on Transboundary Harm are described as draft articles. We submit, however, that the transboundary harm articles reflect general international law, as this court decided at paragraph 152 of its 2010 Pulp Mills decision. In particular, at paragraph 16 of the commentary to Article 1, the articles exclude from their scope harms caused by state policies in monetary or socio-economic or similar fields. It is on such policies that the respondent would seek to rely here to argue that Etania has caused harm to Rahad. Jurisprudence concerning the transboundary harm principle has been limited to examples such as pollution in the 1938 Trail Smelter arbitration, damage from sea mines in the Corfu Channel decision, and nuclear fallout in the 1996 nuclear weapons opinion.
But if the generating principle is that a state mustn't use its own territory so as to cause serious harm to the territory of another state, why is that inherently incapable of applying to refugee flows caused by grossly unfair policies? Let me put it neutrally.
Mr. President, we of course dispute the latter characterisation of the Etanian state's policies, but in respect of the first part of the question, the principle is not inherently incapable of being extended, but as a matter of law, it has not been thus extended, and the respondent relies on it as a principle of customary international law, and there is simply insufficient support in either the practice of states or the jurisprudence of this court and other international bodies to thus extend the principle. Even if, however, this court were to find that the principle should be thus extended.
Would you regard the practice of Germany in 2015, which led up to 800,000 refugees cross the border and did not raise any legal argument against it? Let's say neighboring states would have been Austria mainly. Is that relevant for your vision of customary law obligations or freedoms?
It is relevant, Your Excellency, as to the absence of a customary international law norm requiring compensation from a state of origin to a refugee receiving state. Of course, we accept that the situation here is somewhat different in that Etania and Rahad are neighbouring states, and the alleged refugee outflow has occurred directly from Etania into Rahad. However, on our submission, there is insufficient support in state practice or in jurisprudence to extend a transboundary harm principle to refugee outflows. Dealing, however, with what Mr. President referred to as grossly unfair policies, it is our submission that those precise
policies... It was
policies...
for the purposes of asking a question.
I understand that, Mr. President, of course. However, it is our submission that those policies, contrary to the respondent's argument, were not discriminatory and did not violate human rights. Therefore, even if this court extended the transboundary harm principle to this situation, it would not apply here because Atania has not caused a refugee outflow into Rahad. Dealing with Atania's water resource allocation program, the respondent submits at page 27 of their memorial that that violates prohibitions on discrimination and rights to food and water. We accept that the policy differentiated between those farms producing over $75,000 worth of crops per year at paragraph 35 of the compromise and those farms that do not in respect of its licensing exemption system. We also accept, of course, that discrimination can occur directly on the face of a law or indirectly in effect. However, neither kind of discrimination occurs where there are reasonable and objective grounds for that differentiation. The Human Rights Committee states that in its General Comment number 18 of 1989, and it was reiterated in the 2003 decision of Althammer and Austria at paragraph 10.2.
By decision by which body?
By the Human Rights Committee, again, Mr. President. Here, there were reasonable and objective grounds for this differentiation because faced with the absence of water seepage from the aquifer, the Atanian president determined that Atania needed to allocate additional water to agricultural production. That's at paragraph 34 of the compromise. In a context of extreme drought, economic downturn, and where Atania was facing the loss of over $300 million worth of food and crops per year, as described at paragraph 29 of the compromise, Atania took steps to reallocate water to those farms which could produce the most crops. On our submission, that has reasonable and objective grounds. Now, we accept that when Atania took the ultimate step of terminating water to the majority of farms in kin lands, as described at paragraph 38 of the compromise, that did limit the right to food and water, which are protected by Articles 11 and 12 of the Covenant on Economic, Social and Cultural Rights. However, it is our submission that those limitations were permissible under Article 4 of the Covenant. As this court held in its 2004 Wall opinion at paragraph 136, limitations placed on covenant rights must be necessary and proportionate, compatible with the nature of the rights, and for the purpose of promoting general welfare.
Didn't Atania make a distinction in respect of farms earning a certain profit? And how would you justify that?
It did make that distinction, Your Excellency. It exempted from its licensing regime farms selling over $75,000 worth of crops per year. We justify that on the need to prioritise commercial scale farming in a situation of extreme drought and where Atania's farmland is losing water due to Rahad's actions in depleting the aquifer. In its concluding observations on countries like Jordan, Mongolia and El Salvador in 2000 and 2007, the Committee on Economic, Social and Cultural Rights accepted that necessity in the form of resource scarcity resulting from...
Excuse me. As Covenant on Economic and Social Cultural Rights, I think the entire essence or gist of that covenant is that it is designed to protect the most vulnerable groups. And to my view, precisely the people who do not get water anymore would be the most vulnerable group. Isn't that a bit distortion of the obligations arising of the Economic and Social Covenant?
Not on our submission, Your Excellency. We accept, of course, that the covenant is designed to protect the most vulnerable groups in society. However, that protection is not unlimited, and here the kin refused to purchase licences or to comply with water quotas in a situation where Atania was facing extreme drought. What Atania required was not an unlimited or a substantial interference with the kin's cultural rights as subsistence farmers. What it required was compliance with a system of water quotas which applied Mr. President, I note that my time has
Finish your sentence.
Thank you, Mr. President. That system of water quotas applied to every farm, household and business in Atania, which we know from paragraph 34 of the compromise. May it please the court, that concludes the submissions of the applicant.
Thank you, Ms. Glass. Mr. Lindsay.
May it please the court. My name is Jade Lindsay, and I appear on behalf of the respondent state, the state of Rahad. And with me today is my co-agent, Mr. Victor Brown, and off-counsel Anna-K. Brown. And together we'll be addressing this tribunal for the next 45 minutes. I will spend the first 21 minutes addressing the first two issues before the court, namely that Rahad's extraction of water from the Greater Enata Aquifer does not violate any obligation owed in respect to a shared resource. Secondly, that the Savali pipeline does not violate any obligation owed in respect to the King Canyon complex. My co-agent will then take the remaining 21 minutes to address the final two issues before the court, namely that Rahad is entitled to retain the Ruby Sipar, and finally, that Rahad is entitled to compensation for the refugee crisis caused by Atania. We reserve 3 minutes for rebuttal. Your Excellencies, it is not disputed on the part of the respondents that the principle of equitable utilization is customary and applies. What is an issue here is whether or not the state of Rahad has in fact complied with said principle. First, as a point of clarification, Your Excellencies, it is not the submission of the respondent that 65% of the Greater Enata Aquifer entitles us to an equal and proportionate share of the resource. We submit that there are several factors that have to be considered. And firstly, to establish some context, the Special Rapporteur, Jessup Problem, in his third report on transboundary groundwaters states that when dealing with transboundary aquifers, equitable utilization means the provision of equitable benefits to both states at hand. This is also reflected in this court's jurisprudence in the 2010 Pulp Miss case, wherein the court stated that equitable utilization is not satisfied if the other state does not accrue a benefit. Now, the applicants have submitted...
Mr. Lindsay, did you offer to provide the applicant state with water?
No, we did not, Your Excellency, and that is not a requirement. That is within the sole purview of Atania in exercising its own rights and its own obligations to provide water to its citizens to extract water from the aquifer.
But you're proposing to withdraw water from the aquifer at a rate which will completely deplete the aquifer in 20 years, and hypothetically 35% of the water belongs to the applicant.
We accept, Your Excellency, that there will be depletion of the aquifer within 30 years. And this goes to the nature of the aquifer at question. The Special Rapporteur on Transboundary Groundwater, Special Jessup Problem, states that when dealing with non-renewable resources such as this Greater Enata Aquifer, which we submit it is by virtue of paragraph 18 of the compromise and clarification number 1, that what is not in issue is the maintenance of a minimum level of water, but actually ensuring that the benefit that accrues from the resource can be enjoyed for a prolonged period of time. And he stated that the actual controlled depletion of the aquifer is the benefit. Therefore, Your Excellencies, we submit, contrary to the applicant, for the following reasons: that the benefit does not disproportionately benefit Rahad because, one, by controlling the depletion of the aquifer, Atania has a benefit, and that is the sustainable utilization of the aquifer in question. Secondly, Your Excellencies, we submit that by virtue of...
Sustainable utilization by you?
Yes, Your Excellency.
There is not sustainable utilization by them. So what's equitable about that?
It is equitable, Your Excellencies, because there are several factors that have to be considered. The prior utilization of the aquifer is one, which the applicants have insisted on relying. That is basically the water seepage from the aquifer system. However, there are other interests or other uses that have to be considered. For example, the current use, the potential use, the distribution of the territorial characteristics of the aquifer, and the economic and social demands of the aquifer within the question, within these circumstances. Therefore, Your Excellencies, we submit that by virtue of our maintaining a consistent extraction rate from as early as February 2006 up until the current date, we have extracted less than a third of the total volume of water within the aquifer. Therefore, 2/3 of the water remains for Atania to utilize. However, they have insisted on utilization of water seepage, and we submit that that is inconsistent with a consideration of the total factors that have to be considered when equitably utilizing such a resource.
Where do you get all that stuff from, all these equitable considerations back and forth? Is there authority for that?
Yes,
or
Your
is it just kind of thrown out of a hat?
This is reflected in custom, Your Excellency. For example, the draft articles on transboundary aquifers, Article 5, the 1997 International Convention on the Non-Navigational Watercourses and Their Uses, and the 2004 International Law Association Berlin Rules all codify these principles and factors that have to be considered when equitably utilizing a shared resource. Therefore, Your Excellency, we submit that these are factors that this court ought to consider in determining whether or not the state of Rahad has in fact complied with its obligation to...
But you're not a party to the 1997 convention, right? It wouldn't apply anyway. You're not, do you claim that this is customary law? That
Yes, Your Excellency, as agreed with the applicants that equitable utilization is a customary principle, and this court did in fact state in its 1997 Gabchikova-Najimara's case that equitable utilization is now a part of modern customary international law, and therefore we apply that principle and submit that our actions are consistent with the application of the principle in question. Furthermore, Your Excellencies...
Did the Gabchikova-Najimara's case concern aquifers?
No, it did not, Your Excellency. It concerned a river, but we submit nevertheless that the principle is of general application, and therefore it can be applied to an aquifer, notwithstanding it is different characteristically from a river. Consequently, Your Excellency, we also submit that we have a right to extract from the aquifer. Article 1, subsection 2 of the International Covenant on Economic, Social, and Cultural Rights provides that no state should be deprived of its means of ensuring its own self-sufficiency. Rahad has only extracted at 1.2 cubic kilometers per year, and this is seen in paragraph 26 of the company. Paragraph 21 indicates that only 1.2 is necessary for the self-sufficiency of the state of Rahad, and notwithstanding the influx of more than 800,000 refugees in the territory of Rahad, as seen at paragraph 49 of the company, we have not moderated that extraction rate, and it has remained consistent. Therefore, we submit that our actions are not inconsistent with equitable utilization, and therefore the state of Atania is not entitled to cessation because it is not an international wrongful act.
If someone
you say that even if on present use, you would have exhausted all the water by 2037.
Yes, Your Excellency.
How does that equate with equitable use?
We submit it is equitable in this case, Your Excellency, because at paragraph 22, Queen Teresa stated that the extraction from the aquifer is merely a temporary measure, and that provided that the drought ceases or there is availability of alternate resources, the extraction must end. Therefore, we submit that within the context of this case, or extraction is necessary for the present needs of the society, and consequently, it is equitable to utilize the water presently. Furthermore, Your Excellencies, the applicants have submitted that our actions violate international law due to the harm caused to their farmlands and the lowering of the water table. This relates to our due diligence obligation, and we submit that we have not violated this duty for 3 key reasons. 1, prior to implementation of the Savali pipeline, there was an EI conducted. Secondly, there is no risk of significant harm. And thirdly, there is no significant harm. These 3 factors, Your Excellency, was considered by this court in its jurisprudence.
How do you measure significance in harm? You regard the harm already done to the farmers across the boundary is insignificant? Who has the last word about whether significance or insignificance is given?
This court has the last word, Your Excellency, and the standard that has to be applied was first established in the Trail Smelter case, and it stated the harm must be of a serious consequence. This court subsequently applied that principle in its jurisprudence, for example, the 1997 Gabchikova-Najimara's case, the 2010 Pulp Mills case, and most recently the 2015 border area case concerning Nicaragua and Costa Rica. For example, in the Nicaragua and Costa Rica case, Nicaragua implemented dredging programs in the San Juan River that bordered the territory between Nicaragua and Costa Rica. As a consequence of that dredging, there was a 2% damage to the Colorado River within Costa Rica. The court found in that case that there was no significant harm, and consequently, there was no violation of the duty that Nicaragua owed to Costa Rica.
But the level of damage in this case is considerably greater than the damage to the Colorado. There was a slight reduction in flow, which any dredging operation was capable of causing.
We would disagree on saying that it was considerably greater, Your Excellency. As seen at paragraph 29 of the compromise, the damage to the farmlands is equivalent to $300 million per year. When we compare that to the GDP of Atania, as seen at paragraph 2 of the compromise, this amounts to only 4% of their annual GDP. And consequently, Your Excellencies, we submit that this does not amount to a serious consequence.
I think most governments would regard the loss of 4% of GDP as a damage.
Yes, it might be a damage, Your Excellency, but the issue is whether or not it is serious. And we submit that in this case, it is not serious. Furthermore, we submit that prior to the implementation of the Savali pipeline in 2003, we conducted an EIA. And this is consistent with our requirement in international law.
Did the EIA consider the possible harm to the neighboring state?
Yes, it did, Your Excellency. Paragraph 21 indicates that when ILSA did its report, it considered the structural integrity of the King Canyon complex. And as paragraph 4 of the compromise indicates, the King Canyon complex is on the border between both states. Therefore, it did consider the potential harm that could accrue to the King Canyon complex. Furthermore, in paragraph 25, after we had submitted our EIA to the World Heritage Committee, they noted that there was issues or concerns with land that was located above the aquifer system. And as clarification 1 indicates, the King Canyon complex is not located above the aquifer system. Subsequently, we took steps, primarily the limitation of our extraction zones to 15 kilometers outside the buffer zone to prevent such harm. And consequently, we submit that we have not violated our due diligence obligation that is owed to the state of Atania.
Did you do a follow-up EIA to monitor the effects?
Respectfully, Your Excellency, we did not. However, this is not a requirement. The court has stated that what is the essential requirement is whether or not the state conducted an EIA prior to implementation of the Savali pipeline. The only instance where this court has noted that there needs to be continuous monitoring or a conducting of a subsequent EIA is in the dissenting opinion of Judge Weramantri. Now, for example, in the border area case, Costa Rica conducted an EIA after it implemented its construction of a road along the San Juan River, which bordered both states. And in that case, the court found that there was a violation of the right owed to Nicaragua. In this case, Your Excellency, we have complied with international law because prior to the implementation of the Savali pipeline, we did in fact conduct an EIA, and subsequently we have not violated any obligation owed to the state of Atania. Your Excellencies, I now address the second issue before the court, dealing primarily with whether or not the state of Rahad has violated any obligation owed in respect to the King Canyon complex. Firstly, Your Excellencies, we submit that the harm that has been accrued to the King Canyon complex cannot be attributed to the state of Rahad. At paragraph 30 of the compromise, it indicates that geologists hired by the state of Atania state that the Savali pipeline is the cause of the degradation that is suffered in the King Canyon complex. However, this court has never accepted an assertion of law by an expert when dealing with such facts. For example, in the 2010 pulp mills case, there was dispute regarding evidence proffered by both the applicant and respondent, and in that case, the court explicitly refused to apply Rule 50 of its statutes and instead applied Rule 48 of its rules, which states that this court ought to consider the probative and relative value of the evidence before it. Subsequently, in the whaling in Antarctica case, the court also made a distinction between the finding of the experts and stated that it was this court's purpose to interpret the convention at hand. Therefore, we submit that this court ought to consider on a balance of evidence before the court that the evidence does not show one logical conclusion that the Savali pipeline caused the harm. This is for the following reasons. Paragraph 19 of the compromise indicates that there has been a consistent drought from 1999 up until present date. There has also been an increase of 1.6 degrees Celsius within the temperature of the nomadic coast. As a consequence, there has been severe drought conditions and loss of water. Consequently, Your Excellencies, we say that when we consider the evidence cumulatively, it cannot lead to a logical conclusion that the Savali pipeline caused a degradation to the King Cannon complex. But even if the court refuses or rejects this submission, we submit that our actions are not inconsistent with the World Heritage Convention. The applicants have submitted that we have violated Article 6, subsection 3 of the Convention, but we submit to the contrary. Article 6, subsection 3 states that no state should take deliberate measures that might directly or indirectly result in harm. In this case, two words are operative, deliberate and might. Deliberate, Your Excellency, we submit, speaks to intention. In this case, we have not deliberately taken a measure to harm the King Cannon complex. The Savali pipeline was implemented to extract water.
Haven't you deliberately continued to take action which is capable of affecting the complex? I mean, you may not have thought it would do so at first, but surely there is evidence now that it might, and you're taking deliberate action which could make matters worse.
Yes, Your Excellency, but we submit that
Go on.
We submit, Your Excellency, that notwithstanding, in this case...
I think that was a forensic yes, not an agreement to the proposition.
No, Your Excellencies. However, we submit that in this case, our actions are not impermissible nevertheless, because even if the court finds that our actions are inconsistent with Article 6, subsection 3, Article 5, subsection D provides that a state should take steps within its technical capacity and its scientific capabilities to preserve said cultural property. We did do so, Your Excellencies. As noted, at paragraph 25 of the compromise, the World Heritage Convention made certain recommendations. They stated that there was issues concerning land located directly above the aquifer. After we submitted our EIA to the World Heritage Committee, we took steps primarily limiting our extraction zones to 15 kilometers away from the buffer zone that surrounds the King Cannon complex. And this is seen in paragraph 26 of the compromise. And we submit...
Were those measures capable of helping? Because surely the problem is if you take water out of the aquifer, water flows to the lowest point, and therefore you still get the hydraulic problem that seems to be causing the difficulty.
Be that as it may, Your Excellency, nevertheless, we submit that our actions are permissible under custom. For example, dealing with the Aswan Dam situation between Egypt and Sudan. In that case, Egypt needed to flood the River Nile in order to provide water and agriculture for its population. However, in doing so, that would have resulted to damage to the Abu Simbel statue, which was both of significant cultural importance to Sudan and Egypt, and also other cultural property. Notwithstanding that, Your Excellencies, the River Nile was flooded, and the state of Egypt was permitted to provide water and agriculture to its states. Therefore, the proposition in international law, pursuant to custom, is that if a state has a legitimate economic need, it can destroy cultural property. And in this case, Rahad does have a legitimate economic need to provide water for its citizens because there is a consistent drought condition here. And that need supersedes the preservation of cultural property in the context. But furthermore, Your Excellencies, we submit that there's other international law that supports our proposition. UNESCO, in its draft recommendation on the protection of cultural property endangered by public and private works, states that a state can destroy cultural property provided it takes steps to preserve that said cultural property. And we did in fact take such steps, namely the limiting of our extraction zones at a sufficient distance away from the King Cannon complex. But beyond that, Your Excellencies, we submit that we have not violated the right to enjoy cultural life in this case, because there has been no total deprivation of the right to enjoy the King Cannon complex. This speaks directly to Article 15 of the International Covenant on Economic, Social, and Cultural Rights. The Limburg Principle, specifically, paragraph 72, states that a state fails or breaches its obligation under the covenant where it retards or fails to comply with the steps under that covenant. Article 21, written by the Committee on Economic, Social, and Cultural Rights, states that a state violates the right where its legitimate aim...
Excuse me, what do you mean when you say Article 21 written by the committee? What does Article 21 written by the committee?
It was a very good committee.
But was that a general comment? Or?
General comment number 21, Your Excellency, forgive me, states that a state does not violate a right where it has a legitimate need that it pursues through a proportionate measure. And in this case, Your Excellencies, we submit that the measure taken by the state of Rahad was proportionate for the following reasons. Paragraph 30 indicates that there was only closure of sections of the King Cannon complex, and therefore, in this context, there has been no total deprivation of the right to enjoy cultural life in respect to the King Cannon complex by virtue of our actions. And consequently, we have not violated any obligation owed to the state of Atania. Therefore, Your Excellencies, we submit that in this case, the applicant should not be entitled to an order of cessation because we have not violated any right. Furthermore, it is our right under Article 1, subsection 2 of the International Covenant on Economic, Social, and Cultural Rights to ensure our own self-sufficiency. And by virtue of that fact, there has been no international wrong committed here. Consequently, this court should not order cessation, and therefore the pleadings of the applicant must fail. May it please the court.
Thank you very much, Mr. Lindsay. Mr. Brown.
Good afternoon, Your Excellencies. My name is Victor Brown, and may it please the court, I have the distinct honor of appearing before this tribunal as a second speaker for the respondent state of Rahad. Over the next 21 minutes, I'll be making two submissions, may it please the court. My first submission will address Rahad's entitlement to retain possession of the Ruby Sipar, and second, I will address Rahad's entitlement to compensation from Atania for the harmful consequences of their internationally unlawful act. May it please the court, I'll now begin my first submission. Before commenting the substantive areas of my submission, Your Excellencies, I would like to address 2 points raised by the applicants. First, with regard to the crystallization of Article 7 of the UNESCO Convention of 1970. Your Excellencies, the applicants have not provided any substantive proof as to why this particular article in UNESCO has crystallized under international law, besides their need to rely on that article. Furthermore, we would submit as respondents that if in fact Article 7 of the UNESCO Convention has crystallized as a normative requirement under international law, that it is helpful to the respondent states for 2 reasons. 1, Article 7b subsection 2 implements or states that states should only enter into force the other provisions of the treaty once the treaty has entered into force. So it speaks to a non-retrospective application of the treaty in its entirety. And furthermore, Your Excellencies, Article 7 subsection B also speaks to the requirement on states seeking repatriation of cultural property to provide documentary proof and other evidence to substantiate their claims of ownership of cultural property. The compromise indicates that Atania has failed to provide any documentary proof or evidence to substantiate their claim for the return of the custom of the cultural property in the form of the Ruby Sipar. And agents or respondents submit before this court that in light of their submission that Article 7 is in fact of a customary nature, if this court should accept that view, which we are not preferring, then it is helpful to the respondents.
Surely the object in question was stolen.
Your Excellency, no. In the primary, the respondent submit, it was not stolen. The compromise indicates at paragraph 8, Your Excellency, is that the members of the Kin clan are the only persons who have ever at any time used the Ruby Sipar as an item for any ceremonial purposes. That is significant, Your Excellencies, because it indicates that the Kin are in fact the persons who have the closest cultural affiliation with the item of cultural property. Furthermore, Atania has sought to rely upon their presence at the peace meeting by all the clans of the Atan as an indication of their cultural attachment to the property. However, we have 2 points in response to that. First, their mere presence at the assembly does not grant them a closer cultural affiliation with the Ruby Sipar than the Kin who in fact used the cultural item. And the Kin's cultural heritage rights are protected under the International Convention on Economic, Social and Cultural Rights, Article 15, and further expanded by the Human Rights Committee in both General Comments 21 and 23. Your Excellencies, we submit that pursuant to paragraph 8 of the compromise, paragraph 9 of the compromise, the Kin are the lawful owners of the Ruby Sipar. And as a consequence of that, they have not stolen the Ruby Sipar, but rather carried out actions which are consistent with the customary obligation under international law to take appropriate measures to preserve and protect cultural property.
So you're saying that these human rights instruments, in effect, constitute an alternative law of property rights in relation to cultural property.
No, Your Excellency. What we are submitting is that we as respondents agree with the applicants that there is a customary norm for the repatriation of cultural property. However, inherent to that obligation is an exception that cultural property ought not to be returned to circumstances where that cultural property is to be subject to hostility or the threat of its permanent destruction. And this customary norm and the exception therein is codified in the 2003 Convention on the Safeguarding of Intangible Cultural Property. The subsequent meetings of the working group that formulated that convention stated that individuals as well as states have a customary duty to take appropriate measures to preserve cultural property. And Mr. John Henry Merriman, a proponent of the cultural protection view, in his 3 articles.
Excuse me, could you repeat the sentence? Is it individuals
and states, Your Excellencies, have a customary duty?
How can an individual have a customary duty?
Your Excellency, individuals have a customary duty by way of their participation in cultural protection regimes, and this has been recognized, for instance, by the United States in their Native American Graves Protection and Repatriation Act, and also in New Zealand's Cultural Protection Act.
Would you just be a bit more specific?
The mere fact that a state allows claims to cultural property by indigenous groups within the state doesn't establish an international obligation equivalent to ownership of those by those groups of property which they don't in fact own in accordance with the law of the state where the property is located.
Guided, Your Excellency. In any event, Your Excellencies, we submit that the actions of Ms. Carla Duga in removing the Ruby Sipar from its location in Atania are consistent with customary international law for 2 reasons. 1, Atania has not enacted any domestic laws that prohibit the movement of cultural property within their state. What they have sought to rely upon is an interpretive declaration which they annexed to their ratification of the UNESCO Convention that merely states that cultural property which is removed from their state ought to be removed pursuant to a domestic licensing regime. But there's no evidence on the fact that Atania, in compliance with the terms of UNESCO, actually created any such domestic legal regime, Your Excellencies. Furthermore, we submit that the actions of Carla Duga in removing the Ruby Sipar from the area that it was located in Atania is consistent with international law as 1, she acted on behalf of the Kin clan as an elder sister of the Sun. The compromise indicates at paragraph 9 that the sisters of the Sun traditionally have the role of taking actions to preserve the cultural heritage of all the Atanians.
Are the Sisters of the Sun international legal persons?
No, they're not, Your Excellency. We submit...
So, why do you say that they have these rights if they're not legal persons?
Your Excellency, the Sisters of the Sun are protected as an ethnic minority indigenous group under the General Comments numbers 21, 23 of the Human Rights Committee, also pursuant to Article 15 of the International Convention on Economic, Social and Cultural Rights.
You mean
and
the
we
covenant?
submit...
You mean the covenant?
The covenant, pardon me. Your Excellency, we submit that pursuant to these requirements that ethnic groups be preserved and be protected and their cultural rights of access and participation be safeguarded by states, there is also a duty on the part of indigenous persons in appropriate circumstances to take necessary steps to preserve cultural property by removing them from circumstances
An international law duty.
Your Excellency, we submit that yes, their actions are consistent with international law. And furthermore, even...
I'm sorry, you answered a different question than the one I asked. I asked an international law duty. You said consistent with international law. If I'm not an international legal person, what I do may be consistent with international law, but not a duty.
Your Excellency, we submit that no, there is not a duty placed on individuals to move these properties. However, their actions are consistent with international law. And furthermore, their removal of the properties from the Kin Cannon complex and handing them over to Rahad for their safeguarding are in fact consistent with international law, contrary to what the applicants have submitted. In 2003, there was international outcry by over 140 states against Afghanistan's destruction of the Mamayan Buddhist temples and idols. And we submit that this is overwhelming state practice that indicates the formation of a customary international duty on states to allow and to actually discourage, the actions of other states in destroying cultural property. And we submit that under these circumstances, Rahad is entitled to retain possession of the Ruby Sipar as an item of shared cultural heritage between ourselves, Atania, and the Clean. Yes, Your Excellency?
You said shared cultural heritage. You've introduced a new term in the debate. We now have rules about shared cultural heritage on a transboundary basis. Is that a separate submission of yours?
No, Your Excellency. It is merely substantiating the point that the Ruby Sipar is an item of shared cultural heritage, as I opened by stating. It is not merely the private property that can be exclusively owned by Atania or any other state to the exclusion of others. The compromise indicates that Atania, Rahad, and the kin are all descendants of the original Atan civilization who died out more than 3,000 years before this point. And we submit that we are all, as members of the Nomad Coast, indigenous people, particularly the kin, have a connection to the Ruby Sipar as an item of cultural property, but both Atania and Rahad have some degree of cultural affiliation. However, we submit that because the kin have a closer cultural connection to the object as it has been traditionally used by them, and the only instant in the compromise where it was lawfully used or held for any ceremonial purposes was by a kin member, that this indicates that the kin are the actual owners of the Ruby Sipar. In addition to this, Your Excellency, we submit that Atania's conduct in banning the Ruby Sipar's display and also confiscating and destroying the Ruby Sipar pendants worn by members of the kin is inconsistent with international law, for two reasons. First, according to Atania's interpretive declaration annexed to their ratification of the UNESCO Convention of 1970, any replicas or copies of cultural property that were made in a similar manner ought to be protected by the state from any destruction. And their actions in banning and destroying the pendants is inconsistent with their interpretive declaration. Furthermore, Your Excellencies, General Comment number 21, paragraphs E and D, particularly identify ethnic minorities and indigenous groups as vulnerable groups. And as a consequence of this, they have a specially protected cultural right of cultural access and participation. Therefore, Rahad is entitled...
Gives them the right to steal cultural property in other states.
Your Excellency, and we submit as respondents that the Ruby Sipar was not in fact stolen, but in the event that this court ought to find that it was stolen from the territory of Atania, we submit that there is custom that supports the view that even in the event where cultural property is stolen from another territory for the purpose of its preservation, there is no obligation under international law to compel the receiving state to return it if they are going to take appropriate measures to preserve it, Your Excellency. And this is exemplified at Article 9 of the UNESCO, the 1917 UNESCO Convention, where it states that all states bound by that treaty have a duty to take appropriate measures to preserve cultural property from irreparable harm. We submit that the fact that Atania placed the Ruby Sipar for storage in a vault, a secret clandestine vault within the crumbling King Canyon complex, did not in fact safeguard its use, but rather expose it to harm. And we submit that under these circumstances, the kin did what was necessary and required to remove their own cultural property from the territory of Atania and place it in the custody of Rahad for safekeeping. It is based on the foregoing, Your Excellencies, that the respondents submit that Rahad is entitled to retain possession of the Ruby Sipar as an item of shared cultural heritage owned by the kin, because Rahad is a better custodian, and we will fulfill both our negative and positive obligations under international law to refrain from taking actions that are harmful to the Ruby Sipar, such as exposing it to hostility, and also our positive duty to take appropriate steps where necessary to preserve its physical integrity and the rights of cultural access and participation of indigenous groups. Yes, Your Excellency.
Do you assert a right to retain possession of the Ruby Sipar in the event that the applicant accepts that it will take proper care of the Ruby Sipar?
Your Excellency.
In other words, is your right to retention permanent and unconditional?
Your Excellency, we submit that we could in the future potentially return the Ruby Sipar upon two conditions. If Atania takes positive actions to repeal the legislations within their state that ban the display of the Ruby Sipar, and furthermore, compel the eradication and confiscation of the kin people's cultural rights, then on that condition first, and secondly, if the kin as the owners of the Ruby Sipar agree that they would want to have it returned to the safekeeping of Atania, we would have no legal basis upon which to retain its possession. May it please the court, I will now direct my attention to my second submission before the court. Your Excellencies, Rahad is entitled to compensation from Atania for the harmful consequences of their internationally unlawful conduct. And this is codified in the ILC's Articles on State Responsibility, Article 36, where it states that all states that carry out an internationally unlawful act have a requisite obligation under international law to provide compensation in appropriate amounts to the harmed state. We submit in these circumstances that respondents have to satisfy this court of three things. First, that in fact an internationally unlawful act was carried out by Atania. Second, that this internationally unlawful act resulted in harm to Rahad. And third, that there is a sufficient causal nexus between the harmful injury that has been suffered by Rahad and the original internationally unlawful conduct of Atania. First, with regard to the internationally unlawful act, Your Excellencies, Atania has implemented the Water Reallocation Program Act pursuant to the Compromise Article 37, and this act carries out widespread and systematic human rights abuses against the cane farmer community for two reasons. First, the ICESER clearly sets out that people have a right, particularly indigenous people as well, have a right to food and water. Article 1, subsection 2 of the ICESER sets out that people have a right and they should not be deprived of their means of subsistence farming and subsistence survival. The Water Reallocation Program Act takes away the right of the kin to farm subsistent farming, Your Excellencies. The compromise.
Do you have standing to object to the treatment by the applicant of its own nationals on its own territory?
Yes, Your Excellency. This court in its Barcelona Tractions decision did establish the principle of erga omnes partes, whereby where there are human rights abuses of basic human rights, other states have an obligation under the international community to ensure that those rights are protected. However, the respondents are not relying...
Barcelona Traction had nothing to do with that dictum. The dictum was gratuitous. Is there authority of the court which is closer to this case?
Your Excellency, in any event, the respondents are not relying upon the doctrine of erga omnes partes, as we're not claiming on behalf of the kin. The reason that the respondents are citing the human rights abuses by Atania is to satisfy this court that, in fact, internationally unlawful conduct on the part of Atania did in fact take place. For instance, Your Excellencies, the International Law Association's general principles with regard to compensation for refugee outflows, as well as their declaration on the aversion of the creation of new refugee outflows, were made in conjunction with highly qualified publicist Mr. Luke T. Lee, as well as the UN expert group on the aversion of new outflows. And in their principles...
How do you measure the authority of Mr. Luke Lee? You throw a name at us, could you just...
Yes, Your Excellency. For two reasons, he's admissible before this court. First, pursuant to this court's statute, number 37(1)D, he is a highly qualified publicist who is admissible before this court. Furthermore, his antecedents are contained in the fact that he was the head of the UN expert group that worked along with the ILA on drafting the articles with regard to compensation for refugees.
Is there an example of a state paying compensation for refugee flows?
Yes, Your Excellency. First, the respondents submit that there is a paucity on this matter of states claiming compensation directly for refugee outflows. However, it is our submission that this is not injurious to our claim for two reasons. One, this court...
I'm sorry, I didn't quite catch the first proposition. I asked whether there was an example, and you said yes.
Yes, Your Excellency.
What is the example?
Two examples are, first, in the UN Security Council resolution number 687, paragraph 16, they implemented the UN Compensation Commission, which obligated Iraq to provide compensation to Kuwait and to other states for the consequences of their internationally unlawful conduct, which included forced displacement of persons. And we submit that this provides state practice indicating that, in fact, states have claimed successfully billions of dollars worth of compensation for the harmful consequences of internationally unlawful acts carried out by other states, notwithstanding that international unlawful act was the creation of a forced displacement situation. And therefore, we submit pursuant to Article 36 of the ILC articles that refugee outflows are in fact an international unlawful act and warrant that any state which is injured as a consequence of its creation, compensation. Your Excellencies, another example is the Israel and Palestine proposals on refugee outflows, particularly at paragraph 11 of Palestine's proposal and particularly paragraph 41 of Israel's proposal.
What are you talking about? Can you give a date or a source?
Yes, Your Excellency. Between 1993 and 2001, both Israel and Palestine engaged in negotiations with regard to refugee outflows of Palestinians to Jordan, Israel, and other territories. And in the Taba talks, as they were called, both states tabled proposals with regard to the issues of international law that govern refugee outflows and forced displacement situations, as we have in the instant dispute between Atania and Rahad. And in their proposals, Your Excellency, they stated that host states of asylum seekers ought to be granted compensation for the harmful consequences of the internationally unlawful act of creating a refugee outflow. We submit...
Surely the policy of international law in the matter of refugees is to encourage compliance with the basic principles of non-refoulement and so on, as stated in the Refugee Convention and Protocol. If there was an obligation to compensate, wouldn't that act as a deterrent to acceptance of refugees, which is the fundamental policy at stake?
No, Your Excellency. We submit that should this court find in favor of Rahad that we are in fact entitled to compensation from Atania for the creation of a refugee and forced displacement outflow, this would send a strong signal to states that are prone to creating refugee outflows that they're unable to do so with impunity. To the contrary, if this court should find in favor of Atania that Rahad is in fact not entitled to compensation, this would send a strong signal to the international community that states that are prone to creating refugee outflows can in fact do so with impunity because there'd be no claim of compensation that would follow. And we also submit, Your Excellencies, that the obligation of non-refoulement are pursued.
Sorry, me being
Yes.
the German judge on the court. So who would you, if you were in Germany's shoes, who would you address, or from whom, what states would you, for instance, claim compensation for the refugee inflow of 2015 up to now?
Thank you for your question, Your Excellency. In that instance, we would submit that whichever state, the first state of origin, which was responsible for carrying out human rights abuses, which in this instance would be Syria, they would be responsible under international law to provide compensation to the states which are harmed. And we furthermore submit, Your Excellencies, human rights guarantees of non-refoulement under the Convention on the Status of Refugee are owed by states to humans as their human rights. So the obligation is between states and individuals not to turn them back at their frontiers or borders. However, this does not preclude a claim of compensation by a state which receives forcefully displaced persons and asylum seekers. It does not preclude their claim of compensation from the state of origin for the injury which has accrued as a consequence of that state's international and unlawful conduct. So in this circumstance, Your Excellencies, Atania, by implementation of the RAP Act, in addition to their violation of the cultural rights of the kin, have forced them out of their territory. And the kin themselves, at paragraphs 50 to 57 of the compromise, attest that they're fleeing starvation and the violation of their cultural rights. Your Excellencies, thank you.
Perfect timing, Mr. Brown. Thank you very much. Mr. Phillips, are you... Ms. Glass is doing the rebuttal.
Mr. President, Your Excellencies, 2 points in rebuttal. First, on the topic of Rahad's inequitable use of the Greater Inata Aquifer. The respondent submitted that Rahad's use is equitable under customary international law because there has been no disproportionate accrual of benefits to Rahad with corresponding detriment to Atania. The facts do not support that conclusion of law because Rahad's extraction is preventing Atania's traditional utilisation of the aquifer's natural discharge and has caused damage to Atanian farmland. Detrimental effects are not only relevant to a separate due diligence obligation in respect of transboundary harm, but are part of the determination of what constitutes equitable use, as set out at Article 5, Paragraph 1D of the draft articles on the law of transboundary aquifers, and as reflected in state practice under equitable use agreements like the 2014 Eulamed Aquifer Memorandum and the 2013 Nubian Aquifer Strategic Action Programme. Here, the detrimental effects and Rahad's impacts on Atania's use are crucial reasons rendering Rahad's usage inequitable. Second, on the topic of Rahad's compensation claim, the respondent submitted that state practice supports its claim for compensation for the alleged refugee influx into Rahad. That is wrong in law because the only state practice that the respondents put forward was the Security Council Resolution 687 in relation to Kuwait and Iraq, and there the source of the binding legal obligation was the Security Council resolution itself, which can constitute a binding determination of law in accordance with paragraph 114 of the Namibia
But it was
opinion.
a determination of responsibility, and surely if the Security Council determines responsibility, it's at least to be presumed to be acting in accordance with general international law.
In accordance with general international law, Mr. President, yes.
You may finish.
Thank you, Mr. President. However,
Answer the question as comprehensively as you can.
thank you, Mr. President. It is our submission that state practice is simply insufficient, that one example of the United Nations Security Council does not constitute a customary international obligation compensation for refugee flows, when in 2016, half of the world's refugees came from Syria, Somalia, and Afghanistan, and no compensation has been paid in respect of those refugee outflows. May it please the Court.
Has compensation been sought?
No, Your Excellency, it has not.
Perhaps the reason for not seeking compensation is that you're not going to get it from such countries.
Perhaps it is, Mr. President. However, we submit that for a customary international law obligation to arise, there must be sufficient state practice, and there is simply not in this case.
Thank you.
May it please the Court.
Thank you, Ms. Klaas. Mr. Brown.
Thank you, Your Excellencies. The respondents have 2 points on rebuttal. First, with regard to the water seepage claim by the applicants, that it in fact indicates an inequitable usage of the greater Inata aquifer, we submit in rebuttal that the lack of water seepage by Atania is merely one of the factors that ought to be considered in the equitable utilization of a shared water resource. The other factors that ought to be considered pursuant to the 2015 border areas case includes the fact that there is a shared nature of this resource, 65% of it belonging to Rahad and 35% belonging to Atania. Furthermore, the socio-economic demand on the water resources, the fact that Rahad is in fact a developing state and Atan is a developed country with resources to continue their exportation. Your Excellencies, on the second point of rebuttal,
the law of transboundary resources depend upon the classification of a state as developed, developing, or newly industrialized, or whatever?
Your Excellency, yes. Pursuant to the border areas case, it is one of the factors which ought to be considered by this court. And the mere fact that Atania has only lost the ability to utilize water seepage does not lead to the logical conclusion that they have been entirely deprived or presented with an entire detriment to their state, as they still have the sovereign ability to extract water from the greater Inata aquifer to ensure the water needs of their society, as Rahad has done. Your Excellency, with regard to the second rebuttal, UN Security Council General Resolution Security Resolution number 687 is not the only Security Council resolution that indicates that refugee outflows is an international unlawful act. The resolution number 688, 814, and 837, as well as 119, condemn the actions in Bosnia and Herzegovina, the Haitian refugee outflows, as well as the refugee outflows and forced displacement taking place in Kosovo. We also submit on rebuttal that the article of 687, number 16, speaks to over 140 states that were able to seek compensation from Iraq in relation to forced displacement outflows, and consequently, we rebut the applicant's submission that it is not enough evidence of state practice, as an overwhelming number of states have successfully claimed compensation with regard to forced migration situations, Your Excellencies. Thank you.
Thank you very much, Mr. Brown.
The Honorable Court is now adjourned. Counsel and spectators will please remain in the courtroom while the judges leave to deliberate. All rise.
Please be seated. The comments that I'm going to make come from all three members of the bench, and I start by congratulating both teams for the extremely high quality of their presentations. Jessup problems have a certain genetic structure. They involve issues that would take approximately 45 days to argue, and you have 45 minutes to do it in. They involve propositions that are mutually inconsistent. In this case, one team had to argue that the sic usere principle applied in one context and not in another, despite the fact that it was not obvious that it should do that. And they require you to make arguments that are completely untenable. And to address those problems, you've got to appear to be more reasonable than in fact you're being. And you both confronted those dilemmas, standard Jessup dilemmas, with good humour and grace and erudition, and you're all to be congratulated. In general, the standard of answering questions was of a high order. There were lots of questions, some of them were rather difficult. You complied with the rules, you didn't make up facts, despite several invitations to do so. And if you made up rules of international law, those were rules that you needed in order to establish your propositions. One could make particular criticisms of particular propositions, and I don't want to appear to be churlish, but the Gabchikova-Najmaraj case, which is close to my heart, did involve issues about aquifers, but I won't go beyond that. It was a very difficult task, as I've said, to identify the best speaker, but in the end, and by the narrowest of margins, we concluded that Miss Glass was the best speaker. In any competition like this, you will have mooted this problem, each of you, about 50 times in peace and in war, in contested cases and in practice, and you're probably thoroughly sick of it. And it's unfair that there has to be a winner and there has to be a loser. I want to pay great tribute to the respondent side, whose arguments were very well done with great grasp of the material. But the tribunal, the court, I should say, President Higgins told me off once when I referred to the International Court as a tribunal, something I wouldn't do these days. The court was of the view that the applicant side were the winners.
Sydney.
Sydney, is it? Should be.
Leadership of this organization over the next few years, and particularly honored to do so following in the footsteps of Stephen Schneebaum. Stephen, I hope you're over there somewhere. He has been just an amazing chair, and we're all grateful. It was 15 years ago this weekend that I argued in the Jessup. And I always imagined, or at least dreamed, I'd be standing at this podium, but I hoped it would be facing the other way. But that means that I know what all of you have been through and the journey you've been on this week and this year. And a huge congratulations to our 2 finalist teams, to all the teams who competed, to the coaches, judges, friends of Jessup, bailiffs, and everybody back home who's been supporting you this year. Congratulations. This has truly been the most extraordinary Jessup week ever on every metric, from the number of schools and students participating to how hard the problem was, to how great the final round was. And we owe a lot of that to the Executive Office of the International Law Students Association, particularly Leslie Ben, our Executive Director, who has made all of this possible. Leslie, thank you. Can you believe it was only 6 days ago that you all walked into this room to put those flags up there? It's hard to believe, isn't it? Well, Leslie welcomed you 6 days ago with a quote from Sir Edward Grey, the former British Foreign Secretary. And I think I need to return to it as we close the week. She noted that Grey had said just before the British entry into World War I that the lamps are going out all over Europe and that we shall not see them lit again in our lifetime. And I think Leslie was right, that there are forces around the world, both near and far, that may be trying to dim those lights, to build walls, and to bring down the institutions we care about. But one thing is clear after this week: the forces of light, the lamplighters of the world, are here, and they are strong at Jessup 2017. In fact, I did not see a single fence at the Go National Ball, even if the lights were dim that night. But international law and those lights will be strongest tomorrow when you get on the planes back home and bring the spirit of the Jessup and all that you have done the past week back to your countries around the world. And international law has survived far more challenging times than the moments we live in. In fact, international law is stronger because of those times. When I look back at history and think of the great moments of international law, they were moments of challenge. They were the Battle of Solferino in 1862 that led to the first Geneva Convention launching international humanitarian law just 2 years later. They were the chaos of World War I that led to the League of Nations in 1920, or the chaos of World War II that led to the Bretton Woods institutions just a few years thereafter. They were the horrors of World War II that gave rise to the Universal Declaration of Human Rights in 1948. And even in my lifetime, they were watching the horrors of Bosnia and Rwanda that gave birth to international criminal law as a new field. We do not yet know what will come of the challenging times we live in, but I am confident that it will lead to a stronger version of international law. And I have confidence that international law will not only prevail, but it will thrive. It will not thrive, however, because of the customary international law rules governing non-rechargeable aquifers. Aren't you glad you all know about those now? Nor even because of the sacred words of the UN Charter. International law will thrive because of all of you. It will thrive because the lawyers are the lamplighters. The law students are the bridge builders. It will thrive because the Jessup community is here to stay and will be a source of inspiration and new ideas in this field. So I want to say to you, have fun tonight, but then go home and keep those lamps lit and keep those bridges strong. But then come back here. And when you come back, you will get to take on a new problem. So, in closing, it is my opportunity now to tell you what we're going to talk about next year. So get your pencils ready. Next year's compromis will address the validity of interstate arbitral awards, the capture of a marine vessel, the breach of nuclear disarmament obligations, and the conduct of naval warfare. I'm ready. I hope you will be in a year. So the last thank you I have to say is a thank you to the law firm of White & Case. And I say this now as the chairman of ILSA with a particular sense of appreciation, because it is on ILSA to make sure the Jessup stays strong, and we can do that because of the partnership with a law firm that has given so much of its time, so much of its energy, and so much of its passion to this moot court competition. And we are all grateful to White & Case. Thank you. And it is now my pleasure to introduce Jacqueline McLennan, a senior partner at the Brussels office of White & Case, the head of their pro bono global legal practice. Her own law work focuses on EU competition law. She regularly litigates before the European Commission and courts in the EU and the UK. But most importantly, she judges the Jessup. She judged the Belgian national rounds. She judged the semifinals yesterday. She is truly a friend of the Jessup, and she represents White & Case's warm embrace of this institution and organization, for which we are so deeply grateful. Jackie.
Well, thank you very much, Bill, for such a kind introduction, and I'm delighted to be here on behalf of White & Case. There are around 800 of you in this room. There are many more thousands linked to us through the live stream today. These are remarkable numbers. Now, the Jessup is the world's largest advocacy contest for law students, so such a large audience is fitting. But this year, as Bill said, is particularly worth celebrating. And that's because an unprecedented nearly 650 teams from 95 countries took place in the Jessup 2017 national rounds. For the first time, teams came from Bangladesh, Jordan, Lebanon, and Saudi Arabia. And the international rounds, which you've all been experiencing over this week, they had a groundbreaking more than 143 teams. That was a logistical challenge for many in this room. But there's another cause for celebration for us at White & Case, and that's because this is the 10th year of the global partnership that we have had with the Jessup. And that's a partnership which deepened when we took on sponsorship of the international rounds. You may not know this, but White & Case was founded in 1901 in New York by two people, men, who felt strongly that lawyers should use their skills not just for the benefit of commercial clients, but for the public good. And that's an ethos that's underpinned this firm to this day. And in fact, White & Case became international when in 1926, it founded an office in Paris. And that office was set up to better serve one of its pro bono clients, the International Red Cross, which was based there at the time. Well, we're now in 40 countries, and every office does pro bono work, even where there's no tradition of that. And I can tell you, in many, many of our offices worldwide, we have Jessup alumni. And in fact, this year, I'm also proud to tell you that more than 150 White & Case people have been involved in the Jessup, in judging oral rounds, in hosting the national competitions, and in grading memorials. So like many of you, we really live the Jessup drama, and we've really enjoyed the standard, the amazing standard of the competition today. So this afternoon for all teams is the pinnacle not just of a week of great excitement, but 9 months of grappling with that tortuous problem that you have heard today. This year's hypothetical, which dealt with issues so fundamental, the right to food, the right to water, what are the rights of indigenous peoples, how should refugee populations be treated? This is a problem which is contemporaneous, it's a problem which is very clever, and it's a problem which has highlighted the promise and the challenges of international law. What better way is there to continue the legacy of Philip Jessup? Now, Philip Jessup was a man who didn't shy from the issues of his time. You may not know this, but he left a very comfortable existence and college in 1917 to become a machine gunner in Belgium and in France, and he returned to the US with the desire to end all wars. And he felt that the way to do that was to use international law and international institutions. Now, he worked throughout his life to prevent conflicts between states, and through his many roles, he tried to achieve that. He was a scholar and a teacher. He was even a practitioner, a public servant, a diplomat, and, as you know, a judge at the International Court of Justice. He was a man who was proud to avoid windy rhetoric. Let that be a lesson to us all. And throughout his life, he said he was concerned with practical action as well as new ideas. He was a pragmatist. He said also that the concept that international law was for states alone was outmoded. He saw that individual human rights needed to be protected, and he argued that international law should be used to achieve that. Now, these views resonate at a time when in many of the countries that we might count on to be leaders of the international community, we see an impulse to draw back from communal aspirations and instead to embrace parochialism and protectionism. And populism, fueled by many reasons, not least policies designed by elites which have not delivered to the masses. A refugee crisis and a fear of immigration generally has propelled the United Kingdom to take one example, to do what, speaking personally, I believe to be a ridiculous decision, to take a ridiculous decision, a rash decision. And that decision was made in a referendum last June, when very narrowly the UK voted to leave the European Union. That's a body which has been supranational, which has kept peace in Europe for 70 years, which has enhanced prosperity and established fundamental rights. Now, after 2 important cases before the Supreme Court in the UK, one of which I'm proud to say I brought but lost, the UK government has triggered Brexit and enormous political and economic uncertainty. Now, the impact of Brexit on the EU remains to be seen. There are fears, however, as to its future. And upcoming elections in France and Germany will be key, but already we see a blatant disregard of the rule of law in Poland and Hungary and renewed instability in the Balkans. And, as Bill said, closer, here in Washington, we all know the platform on which the current president has been elected. And we've heard his apparent disdain for the UN, the WTO, and for internationalism generally. And in the last week, we've all been witnesses to belligerent statements and military interventions. So history, and Jessup's example, tells us that at times like these, each of us have to recognize that we have a responsibility to do whatever we can to ensure that reason and diplomacy and international law prevail. Now, at the same time, I think Jessup would have noted with satisfaction that this is a period where there's an emerging set of soft law principles and non-state actors, which is becoming more significant in supporting and developing the rule of law worldwide. an increasingly powerful driver of respect for universal principles of human rights and environmental sustainability, which may surprise some of you, is business. Multinational corporations operate in many jurisdictions where states are unable or unwilling to guarantee basic standards of fundamental rights or environmental protection. And while there are many examples over the years where business has been compliant in abuses and profited from legal laxity, there's been a palpable shift in the past decades of leading corporations' attitude to human rights. Where once business was questioning the relevance of human rights to it, now there's an understanding that this is a challenge they must face in doing business globally. Now, why is this? Well, a watershed event was the adoption of the UN Guiding Principles on Business and Human Rights by the General Assembly in 2011. This has had a major effect in drawing attention to the issue, and it's provided a clearer framework to articulate the role of government and business, and it's had the result of promoting proactive action by leading companies. Now, the guiding principles make it clear that just as states have a duty to protect human rights, corporations have a responsibility to respect human rights too, and both states and companies should provide effective remedies for violations where they should occur. And although adherence is voluntary, the UNGPs are proving to be very powerful. Now, at the same time, it should be noted that there's new legislation which is turning soft guidance into hard law, and that is becoming more prevalent. The California Transparency in Supply Chains Act and the UK's Modern Slavery Act are examples of landmark legislation designed to improve transparency and accountability on human rights. Companies are also subject to increased disclosure requirements on compliance with human rights standards. And in addition to government actions, we have stock exchanges and we have market regulators requiring companies to report on material human rights impacts or say where they're not reporting. And corporations, of course, have to deal with the risk of litigation, the risk of being sued for an alleged breach of a human rights standard. And that's particularly the case these days, where there are allegations of the use of forced labor or children in supply chains. And it's evident that legally required disclosure can increase the risk of litigation. So the legal framework is evolving and it's developing teeth. Now, bear in mind, corporations, it might be said, saw compliance with bribery and anti-corruption standards to be a top priority when the law in that area had clarity and very clearly had impact when sanctions were very severe. Perhaps the journey in human rights compliance will be similar. But in addition, for companies, perhaps even more important than the legal risk is the changing world that business operates in. And we're all a testament to that. This is a world which is more interconnected and more transparent. And increasingly effective NGOs are using the power of the internet and social media to publicize business failures and poor practices. There's a kind of panopticon effect. Corporate boards are well aware of the long-term reputational damage that can result from a failure to meet basic human rights standards. And this can have much more impact than any financial penalty that might be imposed by a regulator or a court. So the role of NGOs and civil society in holding states and corporations accountable for their actions is crucial. Now companies, though, are further incentivized to deliver what might be called ethical profit, because investment funds are imposing specific disclosure of human rights impacts requirements too. So many companies are proactively responding to this environment, and they see now a business case for acting in a responsible and sustainable manner. And so you see that when you look at the human rights and environmental sustainability policies that are put onto the internet. Companies are also making governance changes, and they're conducting deep due diligence exercises, and they're engaging in far-reaching reporting. This is very different to the situation that used to exist. Global business clearly has the power to shape lives and the environment. And through its compliance efforts, it's got the power to raise standards of human rights and environmental protection. And it can do this on a global basis, and it can achieve wider respect of these standards, also on a global basis. Now, lawyers have a role to play here too. Lawyers worldwide are being asked by their bars and by regulatory authorities to build capacity so that clients can be properly advised in the area of human rights. The IBA has gone on record as saying that there is no area of practice where human rights issues are not implicated. So at White & Case, recognizing the wider impact of these laws, we've instituted training all our lawyers are asked to receive. Training globally in human rights law, and we've been working to embed human rights considerations in all our practice areas. And I'm proud to say also that we are a member of the UN Global Compact, which is the world's largest voluntary corporate responsibility initiative, with 12,000 companies and organizations who are voluntarily adhering to fundamental principles. Now, my chairman, Hugh Verrier, described often as a visionary among law firm leaders, often says that large global law firms like White & Case have great power. We can complement and even spur the work of governments and the work of NGOs through the pro bono work that we do, through the skills and the resources and the reach that we have. We can bring significant value add to organizations. For example, in our firm, we've built an online database for the UN Office of Drugs and Crime to fight human trafficking. We can also bring effective access to justice, just as when we won restitution in court for Ukrainian women who had been trafficked to the US. The global practice, the global pro bono practice that I lead at White & Case, focuses on the key issues now facing the world, and it aligns remarkably with the UN Sustainable Development Goals. So why is this relevant for you? Well, Jessup competitors, as we've seen today, have extraordinary talents, and they'll go on, you will go on, to be agents of change in all areas of the legal profession. Whether you find yourself in government, or in the military, or in private practice, or in business, maybe, perhaps, as a judge, your career will undoubtedly give you real opportunities to promote human rights, to ensure environmental sustainability, to challenge injustices, and to develop the rule of law. So I ask you, remember Jessup and his advocacy of practical action based on new ideas, and seize these opportunities. The Jessup, as we all know, is a competition, and a particularly fierce one. But I'd like to leave you now with the thought that one of the great lessons that this competition may teach, counterintuitively perhaps, is the value of collaboration. You are each part of a team. You may have a prize orator. You may have a particularly gifted writer. But you can only win this competition by being the best team. And you've also learned that to do best, you have to first understand your opponent's best argument. And that's what you have to beat. You can't ignore the unhelpful points of law, the awkward facts. You have to engage in constructive dialogue with those who stand opposing you in any Jessup courtroom. And you have to engage in constructive dialogue with the judges who may be pushing you if you're going to succeed before them. So if you apply these lessons in your future paths, whatever they may be, then the Jessup may have prepared you to play a role in moving our world away from the divisiveness that threatens it so much today, using the key power of reasoned exchange and collaboration. Thank you.
Thank you very much, Jackie. While your judges continue to deliberate, I have a few thank yous to express and a couple of awards to give. First, I need to repeat the gratitude that was expressed to the official sponsor of the international rounds and our global partner, White & Case. From your marketing and events group, to your social media department, your social responsibility team, and the attorneys who dedicate the time and effort to judge here and around the world in every aspect of the support from the firm, we thank you and are extraordinarily grateful. I need to thank the members of the ILSA Executive Office without whom this week would certainly not have been possible. Tessa Walker, Tamara Kosick, and Olga Kozlova, thank you so much for all of the work you put in. I want to thank the 3 law students who have served the past year on ILSA's board of directors as student officers of the organization. Anderson DeRossi from the Dominican Republic, our student president. Mena Khalil from the United Arab Emirates, our student vice president. And Shane Young from the United States, our chief communications officer. We've had what we like to call a core group of volunteers who have been here all week assisting in many respects, whom I would like to thank. And at the top of that list is Elizabeth Black. Elizabeth is the global manager of White & Case's social responsibility team, and she oversees the firm's Jessup activities around the world and plays a critical role all week here in our judges' room. We are so grateful to Elizabeth, as well as the team from White & Case that has been here, including Laprina Lindsay, Karina Aquafreda, Ennio Rizzi, and Amity Boy. Thank you very much. I would like to thank and recognize Rusty Dalfrez, who has served as our judge coordinator all week. Michael Pyle, who has served as our scoring coordinator. And a group of other core volunteers who have come from all over the world to work on our team this week. For any that are in the room, please stand and be recognized, although I'm going to read your names, and I hope that we can hold applause until it's over and then really show them the appreciation, because we could not have achieved this week without this group of individuals. Felipe Costa from Brazil. Myra Din from the United States. Jenny Englander, also from the United States. Andre Freo from Brazil. Mariah Hazen from Brazil. Berglind Hermanstotir from Iceland. Julia Heinzen from Brazil. Rafaela Horman, also from Brazil. Megan Matthews from the United States. Emma Medic from the United States. Thais Neves from Brazil. I'd also like to express gratitude to our official event photographers, Ennio Rizzi and Anastasia Zukova. Thank you so much. Thanks to the author of the 2017 compromise, Jeffrey Brooks. Jeff has been judging here all week as well as at various qualifying rounds and has graded more memorials than he cares to think about. I want to thank him on behalf of the Executive Office for all of the hard work that he has put in on the compromise as well as the bench memo. I would like to recognize and thank the board members of the International Law Students Association who volunteer their time and effort behind the scenes to make all of this possible. It's been my pleasure to work with them yet again. I would like to thank the friends of the Jessup. There are, of course, too many to name individually, but the coaches, team advisors, friends, and colleagues who have helped prepare teams and have been here to support the teams, thank you very much. I would like to express gratitude to all of the sponsors and the supporters of so many of the Jessup teams that have competed here this week. The sponsors and the supporters range from prime ministers of some of your countries to your friends and neighbors, and all of those contributions have made a difference to this year's international rounds, having made them one of the most competitive and diverse in our history. I would also like to thank the hundreds and hundreds of judges who have volunteered their time and expertise to judge oral rounds, both here in Washington and in the 65 countries around the world where we had national competitions this year. Thank you very much to the judges. And I'd like to extend a special recognition to all of the individuals who administered national rounds this year. Many of you are here in the room today. If you administered a national competition, please stand and allow us to recognize the contributions that you make to this competition. I have a couple of awards to give out at this particular moment. The first award is the Pamela M. Young Friend of the Jessup Award. Of course, we could not do what we do without the extraordinary support from all of our volunteers from around the world. But the Pamela M. Young Award is given annually to a friend of the Jessup whose service has gone above and beyond the call of duty of a volunteer and on occasion has fundamentally improved the competition. This is one of those years. For the entire history of the Jessup competition, we have scrambled to find memorials judges up to the last moment. And for the history of the Jessup competition, we have had to assign preliminary round matches randomly. This year, every memorial was graded by 4 judges 3 weeks before the international rounds began. That is more than 1,100 memorials graded. And for the first time this year, we were able to assign the pairings according to a team's memorial ranking. And I hope that everyone here will agree that this has resulted in a competition that is more fair, more transparent, and more diverse than this competition has ever seen. This year's recipient of the Pamela Young Award is the woman who is responsible for these 2 fundamental improvements in the Jessup competition. I thank her from the bottom of my heart. And that is why I am proud to announce that this year's Pamela M. Young FOJ laureate is Maria Iseva. Masha, come up here. The next awards I have to present are the Stephen M. Schneebaum Outstanding National Administrator Awards. These awards are named in honor of Stephen M. Schneebaum, who is the founding chair of ILSA's board of directors. Mr. Schneebaum has filled a critical role in the organization and administration of the Jessup competition for decades. The award is presented to a national administrator for outstanding service and dedication to the Jessup competition. There are 4 recipients of this award this year. First, it is rare that a country goes from no teams to many in the span of a couple of years. The first recipient has taken a country that until this year had never participated in the Jessup and never so much as expressed interest in the Jessup, and he has turned it into a high-functioning national round with 16 universities expressing interest, 10 universities competing, and it sent 2 teams here to the international rounds. We are looking forward to the future growth of the competition and to welcoming more Jessup teams from Bangladesh. This first award goes to Nuran Chowdhury of Bangladesh. Creating a robust Jessup culture is always a challenge. In certain countries, this challenge is met by an equal commitment from public authorities and private volunteers. Our next recipients reflect a full commitment from the United States Department of State and from a gifted and committed local expert to work together to create a Jessup community in the country of Pakistan. This innovative approach to the administration of Jessup in one of our newest countries is the reason that I am pleased to award the next Stephen M. Schneebaum Award to 2 recipients, Danielle Hassan and Dawn Calvert. So I was hoping that Danielle would be here, but we will obviously ensure that he and Dawn receive the plaques and thank them in their absence. I feel a little bit bad about this next recipient because she is not just a national administrator. She is so much more. In fact, many of us here in Washington might be surprised to hear that she also runs national rounds and has done so for 4 years running. She is one of the most respected judges at the international rounds and has been for many years. She has been a key advisor to me and the executive office in countless roles, and of course, she's also a brilliant lawyer. In her spare time, she is the Italian national administrator. She has been an inspiration to us here in Washington as to how to use social media to promote the Jessup, not just in Italy, but around the world. She has taken what was once a contentious and disorganized national rounds and turned it into a model for all of Europe. And it's no surprise that under her supervision, and for the first time this year, we saw the Italian champion team progress deeply into the advanced rounds. You share an immense amount of credit for their success. So please come up here and collect your award, Agnesi Pizzola. I had the immense pleasure this year of flying halfway around the world to Kabul and attending the Afghan qualifying rounds. Before I arrived, I knew that this was a country that was very much still in the midst of major conflict and upheaval. I knew that there were judges, competitors, and volunteers who would be in the line of fire and who would be attending the national rounds from conditions that many of us cannot even imagine. I was immensely and pleasantly shocked to find that the Afghan national rounds are not that different from the regional rounds in Denver, or in London, or in Brussels. Wherever we go, Jessup is Jessup. And with much appreciated financial and administrative support from partners all over the world, 2 men were responsible for making the Jessup in Kabul feel like home. That is why I am pleased to award the Best National Administrator to Fahim Samadi and Ramiz Husseini. Concludes the 2017 World Championship final round. We look forward to seeing everyone tonight at the final awards gala. Thank you very much to the judges and congratulations to both teams.